Hi, I'm Sankalp Mishra, and this is Skills in States Weekly Law Review. The Supreme Court on Monday dismissed a petition alleging adoption of a pick and choose policy by its registry and of routinely giving preference to influential advocates in listings. The bench, headed by Justice Arun Mishra, dismissed petition and imposed a fine of Rs 100 in the filing the plea, seeking a direction to its Secretary General and Registrar to not give preferences to cases filed by influential lawyers and petitioners. The Supreme Court on Monday set aside the 27th May order passed by the Delhi High Court, which had directed the National Investigation Agency to produce the records pertaining to the production warrant issued for the transfer of Gautam Navlakha from Delhi to Mumbai. The direction challenged by NIA was passed by Justice Anup Jairam Bambani of High Court after making a prima facie observation that the NIA had acted in unseemly haste to move Navlakha out of the jurisdiction of the Delhi High Court while it was considering his bail application. Allowing NIA's appeal against the HC order, a bench comprising Justices Arun Mishra and Naveen Sinha further directed for the expunging of remarks made by the Delhi High Court against NIA while hearing Navlakha's bail plea. The top court further held that as per its order passed on April 8th, the accused was granted liberty to surrender before the courts at Bombay. Therefore, the Delhi High Court had no jurisdiction to entertain Navlakha's bail plea at the threshold. The Supreme Court has observed that a dispute as to inheritance of shares cannot be decided in proceedings under Section 241-242 of the Companies Act 2013. Section 241 of the Companies Act deals with the application to National Company Tribunal for relief in cases of oppression, etc. And Section 242 deals with the powers of tribunal to deal with such applications. The case pertains to family tussle between a wife and son of late Mr. Abhay Kumar Oswal, who during his lifetime held as many as 5 lakh shares in Mrs. Oswal Agro Mills Limited, a listed company. In this case, NCLT and NCLAT held that the application filed by Pankaj Oswal alleging oppression and mismanagement in the affairs of the company is maintainable. In appeal, the bench comprising Justices Arun Mishra and S. Abdul Nazir noted that Sangram Singh P. Gaikwad and others versus Santi Devi P. Gaikwad, 2005-11 SCC 314, it was held that the dispute as to inheritance of shares is eminently a civil dispute and cannot be said to be a dispute as regards oppression and or mismanagement so as to attract company court's jurisdiction under sections 397 and 398 of the Companies Act 1956. The Supreme Court on Tuesday directed the states of Uttar Pradesh, Bihar, Uttarakhand, and Tripura to file their respective affidavits by Friday in its suo motu case pertaining to the condition of children in protection, juvenile, and foster of kinship homes amid the coronavirus outbreak. A bench comprising of Justices L.N. Rao, Hemant Gupta, and S. Ravindra Bhatt also directed the state of Uttar Pradesh to file an additional reply pertaining to the issue of apprehensions of COVID cases at shelter homes in Kanpur, UP. A review petition has been filed against the Supreme Court's judgment by which a state government order affirming 100% reservation for the scheduled tribe teachers is a scheduled area of Andhra Pradesh was paused. On April 22, 2020, a 5-judge constitution bench of the Apex Court, headed by Justice Arun Mishra, held that the Andhra Pradesh governor's move affirming absolute reservation to teachers belonging to the ST community was constitutionally invalid and therefore struck it down. This was in the case of Sheburolu, Leela Prasad Rao and others versus state of Andhra Pradesh. The court followed the dictum in Indra Sahni judgment and according to which reservations would be constitutionally valid only as long as they do not go beyond 50%. The High Court of Karnataka on Wednesday expressed the prima facie view that state government orders banning online classes encroach upon the fundamental right to life and education conferred by Article 21 and 21A of the Constitution of India. The court said that the executive orders passed by the government under Article 162 of the Constitution cannot curtail the fundamental rights under Article 21 and Article 21A. Further, the court clarified that the orders should not be construed to mean that authorities of school have right to make online education compulsory or will have a right to charge extra fees for conducting online classes. The bench said that there was no rational basis for passing orders banning online education. The fact that state is not able to extend online education to certain category of schools is not a ground to hold that the so-called elite schools should not extend online education to their students, added the bench. Justice Khanwilkar rescued himself from hearing a plea which complained about the lackadaisical state of affairs in the state of Uttarakhand with regard to the FIRs, charge sheets filed by the CBI against several police officers on allegation of committing murders, gang rape, and molestation of women activists during a struggle for a separate state. Justice Khanwilkar rescued himself on the grounds that he had earlier appeared as an advocate on record in connected proceedings before the Supreme Court. The Supreme Court has observed that non-payment of a part of sale consideration is not a ground for cancellation of a registered sale deed. The court was considering the appeal filed against the order of the Gujarat High Court, which had affirmed the order of the trial court, allowing the application filed by defendants under Order 7, Rule 11D CPC, holding that the suit filed by the plaintiff was barred by limitation. The suit was for cancellation of the sale deed, which was executed more than 5 years ago, on the ground that the sale consideration fixed by the collector had not been paid in entirety by the defendant. The period of limitation for a suit seeking a relief of cancellation of sale deed is 3 years, which commences from the date when the right to sue first accrues. In its judgment dismissing the appeal, the Apex Court, comprising of Justices L. Nageshwara Rao and Indu Malhotra, summarizes the law applicable for deciding an application under Order 7, Rule 11 CPC. Referring to the judgment of Vidyadhar versus Manik Rao, 1999 3 SCC 573 and Section 54 of the Transfer of Property Act 1882, the court said that the words price paid or promised or part paid and part promised indicates that actual payment of the whole of the price at the time of execution of sale deed is not a sine qua non for completion of the sale. The Supreme Court on Friday allowed a service of summons and notices through instant telemessenger services like WhatsApp as well as via email and fax. A bench of Chief Justices S.A. Bobde, A.S. Bopanna and Subhash Reddy clarified that all methods are to be employed to prove a valid service on a party. CJI refused the request of the Attorney General for specifically naming WhatsApp as a mode of effectuating service, stating that it was not prudent to specify WhatsApp only. Delhi High Court rejected the plea moved by Sharjeel Imam challenging the decision of the trial court, wherein the Delhi police was granted an extension of 3 months beyond the statutory period of 90 days to complete the investigation against him for offences under Unlawful Activities Prevention Act. The single bench of Justice B. Kameswar Rao observed that the trial court, while granting the extension of investigation, had satisfied itself with the application of the additional public prosecutor about the reasons or grounds on which the extension of time for doing investigation was sought. The court held that the additional public prosecutor had given adequate reasons in his report for seeking an extension to complete the investigation, and the trial court properly satisfied itself of the said reasons before passing the order. The Supreme Court recently set aside a Madras High Court order that had dismissed a criminal appeal against an order of conviction for default. The bench, comprising Justices Rohinton Fali Nariman, Navin Sinha and B.R. Gawai, agreed that the contention put forth by the council, relying on the decision of the Supreme Court in T.S. Panduranga versus State of Karnataka 2013, 3 SCC 721, that an appeal against an order of conviction cannot be dismissed in default but must be taken up and decided on merits, even if the appellant in person or the counsel representing him is not present.